Good evening and welcome to Making the Case. I'm Yodit Tewolde. Closing arguments wrap today in the murder trial of Kyle Rittenhouse, and now the case is in the hands of the jury with deliberations starting tomorrow. In the meantime, a play-by-play breakdown of the closing remarks by both sides with my legal panel of experts, veteran prosecutor and BNC's legal contributor Paul Henderson and criminal defense attorney Sue Ann Robinson. Good having you both back. Let's dive right in, all right? The prosecution gives their closing arguments first, so we'll start there. I actually thought they did a better job in their 2-hour closing than they did presenting their 5-day case in chief. Paul, your thoughts on the state's closing?
I agree 100%, and I knew you were going to catch that same thing. And he made some really good points. It was clear that the judge still was not feeling it. And like one of the things that stood out to me was the judge's behavior. But I love some of the points that the prosecution dropped in there from the very beginning about the defendant expecting and anticipating danger and going to the danger with a gun. I thought those were really strong points, and their argument was soaring in those areas. Also, when the prosecution was talking about how the defendant continually left a safe place and went out into the crowd and then encountered what he feared and then used force against it. So I wish that I had heard the prosecution say, and this was while I was taking my notes, I wished I'd heard the prosecution articulate a reminder to the jury that they have to evaluate self-defense each and every time use of force took place with each and every victim and each and every person, well, we can't call him a victim, with each and every person that was shot. But I wish that the prosecution had talked about creating a new standard each time for a fear that had to be reasonable and use of force that had to be justified. But he did a better job today than I'd seen throughout the whole trial. I agree.
Sue Ann, your thoughts?
Yeah, Judge Schroeder has been killing the prosecution case slowly from the beginning. From the outset, when he made the ruling on the victim matter that they couldn't be called victims and he was going to agree to them to be called looters and arsonists, he started gutting the state's case. He essentially didn't allow the state to enter any evidence as to motive or the mindset of the defendant, even though he was on the stand. He wasn't permitted to ask him about certain affiliations, his posts on Facebook, things that would provide a story to the jury as to why someone would go to this danger, because he has these certain affiliations. And the Judge Schroeder / part-time Rittenhouse defense team, in my opinion, completely gutted the prosecution's case and then threw out the gun charge on the eve of closing. Let me tell you, as a trial attorney,
we're going to get to that. Wait. Sue Ann, we got to save that. We're getting there. You're jumping ahead now. Hold on. Here's prosecutor. Let's listen to prosecutor. That's okay. Let's listen to Prosecutor Thomas Binger talking about provocation.
When the defendant provokes the incident, he loses the right to self-defense. You cannot claim self-defense against a danger you create. That's critical right here. If you're the one who is threatening others, you lose the right to claim self-defense.
Okay, so Sue Ann, you can't claim self-defense according to the prosecution if you provoked, and the law, if you provoked the situation, but if your actions cause someone to attack you and then you reasonably fear death or imminent bodily harm, then you can use some level of self-defense after exhausting all reasonable means to avoid confrontation, right?
Right. You have the duty to retreat after you're the aggressor attaches. I just think the issue with this provocation argument goes to both of your points, which is a lot of the state's argument is Johnny-come-lately stuff, like things that we all thought from the beginning, but he just didn't get the evidence in. And he even was saying it in his closing, like we were trying. He was using the word try. We tried multiple times, telling the jury like, hey, we tried to get certain things in, or we tried to show you this or explain to you that. But I honestly believe for a case that was gutted and took a tremendous blow right before closings, he did a good job. He gets a C from me.
All right, so the prosecution also brought up the lies that Rittenhouse told to bystanders and the press about him being a certified EMT. Rittenhouse testified he wanted to provide medical assistance to folks and protect people's property. The defense never brought any of this up and only argued that their client was under attack by rioters. Should it matter why this 17-year-old kid was in a different state with a rifle in hand, lying about who he was in the first place, Paul?
Well, yes, it should. And let me answer your question with another question, because this is what was in the back of my mind. What would have happened had this been a young black kid with a gun illegally that, let's say, went to like a MAGA rally and then felt unsafe and defended himself, and then 2 people were killed and a 3rd person was shot? It just feels like a very different approach and a very different case, and that's because of race. And we weren't talking about race in this case, but to your point, that is exactly why that argument makes a difference. I just like to color it, no pun intended, with race to evaluate whether or not these same arguments would have been made by this judge, by this jury, and by the advocates on both sides in the courtroom. And, you know, I can't say that I have a positive outcome based on what I've seen, but for this case, we have a very different analysis, and I think defense attorneys took advantage of that and painted a picture of an unruly society as if this defendant were some sort of hero and was some sort of vigilante acting on behalf of not just law enforcement, but for values that needed to be defended against an unruly and a wild crowd. Still just ignored the fact that he put himself in that situation and brought a gun to the situation and then felt unsafe and acted as he thought would be appropriately, and maybe not illegally if we listen to where this jury looks like it's headed.
Sue Ann, the prosecution also reminded the jury about another lie that Rittenhouse told. For example, he told bystanders that he shot Joseph Rosenbaum, who was the first shooting victim, and told folks that he basically pulled a gun on him, knowing that that wasn't true. He testified on the stand that he shot Rosenbaum in self-defense. So why lie on the night in question? And will this matter to the jury?
I think it's going to matter to the jury, and this is his state of mind is the most important thing in the case, because he is charged with high felony murder. That premeditation has to be there, and that has to do with the state having the opportunity to introduce evidence about the state of mind of a 17-year-old who asked his mama to drive him to another state while he had a rifle that he purchased under someone else's name and brought it to another state where he knows there's protests going on, there's issues going on. He's not trained. He's not a trained EMT. He has no law enforcement experience. He has no training and experience in anything. And he shows up to the protest armed. His state of mind is the most important piece of the state's case. And I just feel like there were parts of the cross-examination that were very disjointed when the judge would kind of jump in and make his own objections, objections to things that the state was asking the defendant. So that's kind of, goes into the theme of me saying Judge Schroeder's been killing the prosecution softly this whole time.
I don't know about softly, but he definitely was killing them. We're going to get into the judge in the next segment. We got to take a quick break, but when we return, we're going to be talking about the charges that the jury has to consider. And later, one of the defense attorneys tries to kick Reverend Jesse Jackson out of court today. You'll hear the argument and the judge's ruling when making the case returns. Bruce Schroeder, the controversial judge presiding over the Kyle Rittenhouse murder trial, dismissed one of the charges against the 18-year-old before attorneys gave their closing arguments. The charge, a misdemeanor, was for possession of a dangerous weapon by a person under 18. Rittenhouse still faces 5 charges, including 2 counts of intentional homicide. Back with me, Paul Henderson, BNC's legal contributor, and Sue Ann Robinson, criminal defense attorney. All right, here was the judge's reasons for dismissing the possession of a dangerous weapon charge. Listen.
If the barrel length is less than 16 inches or an overall length less than 26 inches, then I'll deny the motion. If it does not meet those specifications, then this defense motion will be granted.
We are not disputing that the barrel length is appropriate.
Paul, it's a
These are the
misdemeanor,
moments.
albeit it's one of the charges the prosecution could have gotten a conviction on. Actually, let me ask Sue this, because she's the one that was talking about this in the last block. Okay, so the judge dismisses this. The defense found an exception in the law. Is this telling of how unprepared the prosecution was for this case?
He did not have support in the office. And that moment right there told you everything. The fact that rocked him, he should have been, okay, we already ran through this scenario in case this crazy judge did this. So boom, we got da-da-da-da-da. He really drew pause. And it really, to me, what I saw is it kind of took the wind out of his case, because I think, everyone kept saying, well, you could assuage the public at least if you can get this gun charge. I mean, it's obvious he's under 18. He had a gun. It looks like an AR-15. At least if you get that, you can assuage the public and save, and say, listen, I did the best I could. But when you lose the gun charge that everybody's saying is the only thing a lot of people are saying is the only thing on the information that's charged correctly, you're just standing there like with your pants down. What does he do? Him arguing that provocation was great, and arguing the lies was the next best thing to jump to. So he certainly recovered. And I think him taking that hard punch with the dismissal of that and him genuinely being shocked is what really got him to start fighting in the closing.
Paul, in light of the dismissal, the prosecution asked the judge to let the jury consider several lesser charges if they acquit him on the original counts. I see this as sort of a double-edged sword. Your thoughts on that?
It's always a double-edged sword, because if you include lesser included, you give the jury an open door to scale down your confirmed charges. And so as they find guilt, they may find guilt for lesser included charges, which obviously means that you get less time for those charges. And to me, this was more a ruling while this judge was talking about setting up in the framework for the jury, because remember, the jury determines the facts. The judge determines the law. And his interpretation of the law, to me, was one of, I thought was going to be the final, not take his breath away, but an actual sock in the gut for his argument, because this was moments before the prosecution was expected to argue. But to me, the real twist on interpreting those jury instructions and what he told the jury was his freestyle conversation, where he's telling the jury about, and if you find them guilty, whereas if you find that he was able to use self-defense, then you can just stop considering all of the other lesser charges altogether. He didn't even read from the jury instructions the verbatim language. It was really decimating, I thought, to the prosecution, so much so that the prosecution kept their arguments the same and included those allegations in their closing arguments just to present the argument to the jury, even though there's no possibility of convicting on that gun charge. A real disappointment.
Well, here's another exchange between the prosecution and the judge that left the judge confused. Listen.
What the jury is being told is if you can't agree unanimously, then consider these lessers. But I don't think it's so clear as it should be.
It says if you are not so satisfied.
I know it. That's at the very end.
And I think what the court was originally proposing is telling the jury that if you're unanimous on the charge count one way or the other, then you go no further.
I like that.
That's not the law.
If you're unanimous on...
So, for example...
if you're unanimous on the legal question, intentional... Well, you're right, because it could be an elements issue.
The jury...
Maybe the constructions committee is right. I don't know.
All right. Sue-Ann, if this confuses a judge, then how can we expect a jury to understand?
He's not confused, friend. He is not confused. He knows exactly what he's doing. He knows exactly what he's doing. There's no confusion. Judge Schroeder is an experienced jurist. He deals with this prosecutor a lot. The defense attorneys change, but the prosecutors don't. Judge Schroeder knows exactly what he's doing. That's from the beginning.
Paul.
It's like,
Paul,
Let me
Sue Ann is just determined. She is saying this judge is a defense lawyer, period. With a black
There
robe
you
on.
go.
Your thoughts?
say it out
And
loud.
if you have any doubts about that, look at the subtleties while the prosecution is talking. On top of the point that we just made about him being confused about his own state of the law that he was giving to the jury, sir, that is your job. That's what you do every day. And we know,
Good job.
confused, they are not convicted. But if you have any ambiguity about how the judge felt about this case, if you watch the prosecution put that case in, look behind the prosecutor to see the judge, and you will see him while he is making his closing argument in this very important case. The judge is having a side conversation with his clerk. At one point, he stopped and was pouring milk and made an entire cup of coffee and drank it while not paying attention to the prosecutor, and then proceeded to flip through whatever on his computer on his desk while the prosecution was talking. If that is not a sign and an indication from the jurors as to whether or not this is even important or what to pay attention to, I don't know what is. This judge has heard this case from the beginning, and there's no ambiguity in my mind that he is disproval. He disproves of both this case and of this lawyer. It's really a shame, and it's a tragedy in this case that has such bigger issues for us to be examining and looking at.
All right, guys, we take a look. We've got to go to break, but we take a look at the panel of 18 jurors, 8 men and 10 women, who will be narrowed down tomorrow morning to the 12 who will decide the fate of Kyle Rittenhouse. And later in the show, it's not often you find Democrats and Republicans agreeing on anything these days, but they have in the case of Julius Jones. Millions have signed petitions and hundreds have marched calling for Julius's freedom. So why is he still facing execution later this week? We have the latest on the final push to save Julius's life when Making the Case continues. Tomorrow, they'll consider several charges against Rittenhouse. The most serious ones are first-degree reckless homicide in the death of Joseph Rosenbaum and first-degree intentional homicide in the killing of Anthony Huber. Rittenhouse is facing a life sentence if convicted of those charges. Still with me to continue our post-closing arguments discussion, veteran prosecutor and legal contributor Paul Henderson and criminal defense attorney Sue Ann Robinson. All right, so Sue Ann, in the middle of reading the 36 pages of jury instructions this morning, the judge sent jurors out of the courtroom because there seemed to be some confusion in the wording. First of all, who's reading 36 pages of instructions, and how will that exacerbate the deliberation process for these jurors?
Well, the jury instructions part is never in shows or movies because it is the worst part of trial. And you do have to read all the jury instructions, and it can be pretty lengthy. It can take an hour, depending on the case, depending on how many charges. So this is like the non-sexy part of trial. But I think the judge actually interrupting that and stopping that, it's like his signals to the jury are just unbelievable. The shouting at the prosecutor, having the jury outside the presence of the courtroom, but shouting at the prosecutor, it's not soundproof. You know what I mean? Like, I'm sure they can hear someone's yelling. You know, it's just, he didn't do a good job.
Paul, the panel of 18 jurors, 8 men and 10 women, they're going to be narrowed down to 12 who are going to deliberate the case by a random drawing tomorrow morning. Is this, I assume that there were 12 already chosen and the alternates were in court listening to all of the evidence in the event that one can't finish out their duty as jurors. Is this sort of normal with this drawing?
No, it is not. I haven't seen this before. But the other thing that we didn't talk about yet is my understanding is there's only one person in that entire pool that is African American. So don't make me do math live on TV. That's why I went to law school. But it's not a good chance, and we have a really high likelihood that this is going to be an all-white jury. And the only reason I raise that issue is because I think we haven't had intentional conversations about race in this case. And I think that's important, especially in a case like this that's testing the boundaries of vigilantism and people acting on behalf of law enforcement and self-defense with people acting on their own beliefs in terms of what they believe they can do in terms of use of force against other. And again, we're talking about another white man. I think it's important that we keep raising the issue of race because we can't eradicate race disparate outcomes unless we're talking about race intentionally. And so the fact that we are going to get a very likely all-white jury to determine these issues that disproportionately affects people of color, and that's at the core of this case because we're talking about a Black Lives Matter movement, which, by the way, we've had 90 bills supporting anti-riots since those movements from last year. This case is really important, and I think just has to keep bringing up the issue of race.